With apologies, I'll deliver my comments in English, and I will address, I will compare some of the features of the court and its judicial review powers. Doesn't work? I don't need it.
Try to no, we need it.
I'll compare the court and some of its powers and features to other systems, looking at the big picture, and then I'll propose to the suggestion by Chief Justice Barak that constitutional amendments could possibly be unconstitutional. I'll also discuss whether the existing so-called constitution may not itself be unconstitutional, and, for good measure, as perhaps the only real formalist here, I will limit my comments to the 5 minutes allotted to me, which is what I was instructed. Unlike Supreme Court justices, I just follow the rules, even if past practice deviates greatly from them. The in various features override composition of the court. One can point to other systems with similar features. Many countries have judicial review without an override. Many countries have a committee that helps select the judges. Many countries have weaker standing rules than the United States. And so the features, each power of the Israeli Supreme Court is not unique, but it should not be looked at in isolation. What is unique is the combination of these powers. The combination of a system in which the political branches are almost entirely divorced from the selection of justices, where the court itself has complete control of its own docket, where it picks all of its own cases, where there are no limitations on standing, where the court can act essentially like a legislature, taking up an issue whenever it seems like a good idea, and when there are no substantive restrictions on the scope of issues that the courts can consider, which exist in almost all countries. For example, last week we saw what in Israel was considered a great exercise of judicial minimalism, which would have been a flagrant violation of the judicial rule in any other country. The court said the operation of the army with regards to the Gaza fence, it seems like obviously not so crazy, and it's the field of military operations where we give vast deference to the army. Sounds good? I can tell you in the United States the court would say this is a case about actual military operations. We just can't hear the case. It doesn't matter whether the army made good rules, whether they made new rules, whether it looks crazy, whether it looks uncrazy. We can't hear the case. There's a wall being built in Jerusalem to protect the new U.S. embassy. So the court said, you know, it's a very good reason to build a wall and violate existing zoning rules or disregard zoning rules. It's a very good reason. The court in the United States would say, we don't care if it's the best reason in the world or the worst. We can't hear the case. That, coupled with the lack of a written constitution in any coherent form, which I'll discuss, the lack of the government's power over its own legal advisors, disadvantaging it in constitutional litigation in the courts, and the willingness of the court, of the justices of the court, to engage in the political arena in a form more resembling politicians, that is, to assert their privileges, speak to newspapers, argue with politicians. That combination of features is unseen anywhere in the world. Now, when I say no constitution, of course one can say there is a constitution. What do I mean by there not being a constitution? What is the principle of constitutionalism? It's not that something be written. As John Marshall pointed out, the sovereign in the United States is not the Constitution, but the people. And how did the people get to make the Constitution? Through a supermajority. And the basic rule of constitutionalism is the same way of a law. Is the way you get in is the way you get out. One court can overrule another. One legislature can overrule another. One supermajority can only be overridden by a supermajority. That's what makes constitutions special, and that is why the Supreme Court in the United States can override legislation passed by a majority, because it is speaking in the name of a very deep supermajority that was required to pass the Constitution. In Israel, the basic law on human dignity purports to pre-commit and limit future Knessets, but was passed under a simple majority rule. That itself is the antithesis of constitutionalism, that one Knesset can bind all future Knessets, limiting the democratic power of the people, not just in one Knesset, but in all future Knessets. Recently, the Supreme Court told us, Bagatz told us, regarding the gas deal, that a long-term gas price contract is unconstitutional because it limits the power of the Knesset. Now, of course, it does not limit the power of the Knesset because under the basic principles of law, a future Knesset can simply override that gas clause, make the gas company mad. It would be hard to enter into future contracts, but it would be lawful. If the gas contract is unconstitutional because it limits future Knessets, certainly the basis of Israeli constitutionalism, the human law and basic law on human dignity, is unconstitutional because it limits broadly the power of all future Knessets.